Michael O'Neill is a senior official at the Landmark Legal Foundation. I've known him for decades. He's a dear friend. And Michael and Matt and the president of Landmark, Pete, and two other lawyers that Mike will mention, filed a fantastic brief, argued the case in Florida on the Appropriations Clause, as did lawyers for Attorneys General Meese and McCasey, as did President Trump's lawyers, and they won the day. Mike, how are you, buddy?
I'm well, Mark. How are you?
I'm doing great. First of all, you used probably the top expert in the world on the Appropriations Clause. What is that gentleman's name?
Certainly, Seth Tillman, and he is a guru on this. He and Josh Blackman. Josh Blackman's a constitutional law professor in Texas.
And by the way, let me just say, both of those men have been on the show, and they're both absolutely brilliant. Go ahead.
Yeah, the foremost experts on this issue, and Judge Cannon, to her immense credit and her bravery, accepted amicus briefs on behalf. We, along with Josh Blackman and Seth Tillman, filed an amicus brief. She accepted it, and we were able to posit arguments arguing about the unconstitutionality of this appointment of Jack Smith. And as you just said, she accepted briefs from former Generals Mukasey and Ed Meese, and of course credit to the attorneys for President Trump, who also argued the impropriety of this appointment.
What impact specifically did Landmark's brief have? Does she cite it? She wrote over 90 pages. It's an extraordinary opinion. It's like a law review decision.
Right. It's an incredibly sober and well-reasoned decision. Now, we offered an alternative argument. We offered an argument where we posited that the office of the special counsel was not a continuing office. It didn't exist in a continuing manner, and therefore he couldn't function as he was purporting to function. He couldn't function as a U.S. attorney, exercise these sorts of powers. Now, she does address it. She didn't accept it, but she addresses our argument. She says that the other arguments, particularly the constitutionality and the statutory arguments, were really the ones that drove home this issue. But she does address our argument. I think it was important. What's important to do in these amicus briefs that we file is to give alternative arguments and to press the issue. You can't always understand that the litigants are going to advance these aggressive, novel arguments in every instance. So what we want to do at Landmark and what we wanted to do is present an alternative argument, and we gave her the opportunity to do just that.
So she basically says, look, violates the Appropriations Clause. He's not an inferior official because the Department of Justice didn't have any statutory authority, whether they issue a regulation or rule or not. Not a constitutional official because he was not submitted to the Senate and the confirmation process. And there was no budget that was passed by the Congress to provide for this non-existent office. That's pretty much the three things she said, correct?
Absolutely. And it's important to talk about this. You said that it was 93 pages. This is an incredibly sober and well-reasoned decision. You're going to have all these armchair lawyers who probably don't even read the opinion, for heaven's sakes. You look at X and you see these flash decisions or these flash opinions, and it's clear that these folks haven't even bothered reading the opinion. You have this well-reasoned where she engages in this really she utilizes these sophisticated tools of statutory construction to ultimately conclude that the appointment of Jack Smith is improper. And, you hear these people say, well, she discounted this, she discounted that. She devotes pages and pages of her opinion into analyzing these statutory provisions at play. Again, she goes not only to the text and the plain meaning of these statutes, she looks at the historical context, where they fall within the United States Code. It's a really incredibly well-reasoned decision. And what's really important, Mark, is that she took her time with this. She didn't rush. She held multiple days of hearings on this particular motion. She issued a very sober, extensive opinion. She didn't just rush through in an outcome-determinative manner. She weighed the issues accordingly and did her due diligence. At one point in her opinion, Mark, she's reviewing a particular case, U.S. versus Nixon, and she actually says she reviewed every single brief filed in the Supreme Court case, every single opinion, every single brief, every piece of paper that was filed in this to determine the propriety of the applicability of that particular case. It's a really great decision.
And the gentleman who argued the case for Landmark, for us, he indicates that, in fact, she did cite the Landmark brief on several occasions in the brief. Did you catch that?
Yeah, she cites it. There's this issue called the de facto officer issue, and she cites a landmark brief there. She talks about it in context. Professor Blackman was able to provide some historical context through oral arguments, and she also refers to those issues that Professor Blackman raised. So there are multiple instances in this opinion where she talks about the brief that we filed.
And I'm reading some of the news reports, and you're exactly right. These reporters haven't even read the case. They basically say that she's reversed years and years of practice and so forth and so on. Mm-hmm. She's not there to rule on years and years of practice, is she? She's there to rule on what is presented to her as a judge, correct?
Exactly. And the immensity, she understands the enormity of this situation. You have an individual in Jack Smith who, as you said, and you said repeatedly, that he is not subject to any kind of oversight. He was never subject to an appointment like every other U.S. attorney, even though he's exercising powers well in excess of any U.S. attorney in the country, and yet he was never subject to any kind of confirmation process. As you've pointed out in the past, Mark, he's not subject to impeachment. That means the House and the Senate can't remove him if he's acting ultra vires or acting unconstitutionally. He's not subject to any kind of supervision from the Attorney General. And this is an important story. This is an important point that was actually hammered home a little bit in oral arguments. Judge Cannon actually asked the attorney for the special counsel, said, can you provide us any instances where the Attorney General has actually exercised supervisory authority over special counsel Jack Smith? And they refused to do that. The regulations, the DOJ regulations, provide no instances where the AG, the Attorney General, has any kind of authority and supervisory capacity. It's utterly deficient. This individual is...
Let me underscore the point you're making here. Let's slow down just a second. What you're saying is he's acting like an independent counsel, even though they claimed he's nothing more than an inferior appointee reporting to the Attorney General. And when the judge said, okay, can you give me any examples? They didn't. Correct?
Exactly
okay.
Right. Exactly right.
So, ladies and gentlemen, here's the problem. We have a constitutional construct that's set up. The Appointments Clause was put there historically, and it was debated at great length at the Constitutional Convention. That's discussed in the Federalist Papers. And what? Well, they didn't want this executive. They created the presidency to have all this enormous power, where they could appoint friends and this, that, and the other, and no say-so by Congress. But on the other hand, they didn't want Congress to have all this enormous power where they could obstruct this new executive position they're creating from actually getting anything done. And so they created this Appointments Clause. And it's very specific. It can't be clear. Look, there's certain types of officials you got to send to the Senate that has to confirm that individual. And if they're inferior positions, Congress has to pass a statute and give the authority to the president or this agency or that agency to do it. Isn't it also true, Michael O'Neill, that when it comes to passing a statute, giving a cabinet secretary the power to make such appointments, that Congress has done that for several departments, but has specifically excluded the Department of Justice?
Exactly. Congress knows what to do. And there's this statement: the Congress doesn't hide elephants in mouse holes. And Congress knows what to do. If they want to convey this authority to the Attorney General, you don't have to look in Section 515 or Section 533 and parse the language and try to find this imaginary authority. It's just not there. And again, I refer anybody to read this opinion. 93 pages where page after page she engages in this sophisticated statutory textual analysis, and she can't find that authority.
So the bottom line now is this doesn't just affect the so-called documents case. Mm-hmm. This ruling affects the January 6th case, and now Judge Chunkin has to figure out what to do about this ruling. Isn't that correct?
I think so. I think you're absolutely right. I mean, she says at her point that he is functioning ultra vires. He is functioning extra constitutionally. He has no authority to do this, and everything he's done, everything he's done has been improper. Therefore, none of this has occurred from a legal constitutional standpoint.
So that leaves the possibility that if the Department of Justice wanted to, they could start all over again, I suppose. But that raises a lot of practical litigation issues, doesn't it? In terms of all this stuff that was done ultra vires by the federal government. Can they, in fact, use it? So for all intents and purposes, if the Department of Justice wants to rekindle this case, they're going to have a hell of a problem, aren't they?
Absolutely. They have to start from square one and completely begin again. So the question here, of course, is whether this is what's going to happen next with it, and whether they're going to try to subject this to a stay on an emergency appeal. We'll see.
Well, good luck. Number one, the Supreme Court's on vacation.
Yeah.
Number two, when they come back, they're not going to be in any hurry, just like they weren't in any hurry with the immunity case. And number three, I suspect the Supreme Court's going to agree with Judge Cannon, don't you?
I think so. I mean, you saw in the Trump immunity case, you saw Justice Thomas in his concurrence address this very issue. And I think, and if you read the opinion, Judge Cannon references Justice Thomas's concurrence.
Mm-hmm. I don't even know what leg the government has to stand on. You know, I read the decision. Mm-hmm. I'm aware of our arguments. I'm aware of the other arguments. They really don't have a leg to stand on, do they?
Yeah, exactly. I think so. And, you know, it just shows the arrogance of the Department of Justice that they could pull this individual who was outside of the government, a private individual, and vest him with this enormous power. Essentially, what's he trying to do, Mark? He's trying to disenfranchise tens of millions of people. And to have this enormous power in this, just pull some private guy who's never been subject to any kind of confirmation or anything is really beyond the pale.
Mm-hmm. No oversight, no authority, no basis constitutional, statutory for his appointment, and yet Merrick Garland appoints him because he wanted to appoint him, right? He wanted this guy in particular because the Deputy Attorney General, who's really the invisible hand behind this department, knew him, liked him, and wanted him because he's a hunter, isn't he?
Yeah, inside baseball, but it's come back around, and it doesn't look like it's working out for them, does it?
Now, it's interesting. This guy's a screw-up. He did grave damage to the former governor of Virginia, Bob McDonnell, by basically rewriting a statute. The obstruction statute, he basically rewrote with the rubber stamp of Judge Chutkan and this three-court panel in the circuit court in D.C. with two Biden appointees who probably spent about 5 minutes writing their opinion. The Supreme Court takes it up and reverses them. Then on the immunity thing, he's in a hurry. And don't you find it interesting also, Mike, that all the legal analysts on TV originally said that the immunity argument was ridiculous that Trump was making? There was only one who said, wait a minute, that's not true. Or that the documents case is a slam dunk and they're going into the substance. Right. Wait a minute. There are motions to be filed when you litigate, whether at the district court, even at a circuit court. There are motions to be filed. You got to get through. You know, you're running a race. You got to jump the barriers that are put in front. And all these analysts are wrong, and yet none of them confess to it. You see it, don't you?
Absolutely. The arrogance is astounding to me, and this disrespect for the due process and the rule of law. When you're accused, think about the full force and power of the federal prosecutorial process being waged upon you. Think about it on me or on President, the millions. What have they spent? How many millions, tens of millions of dollars that this individual has spent trying to prosecute Donald Trump? And the arrogance. And until you hold these individuals accountable, until you have a judge who's going to give a fair... Now, let's talk. Judge Cannon was equally hard on all parties here. She gave due process and due consideration to everybody. She was fair and she was open. There was no prejudice here. In oral arguments, she was just during the hearing, she was just as hard on the lawyers for Trump as she was on the lawyers for the special counsel, as she was on the amicus for our position, as she was on the amicus on the other side. She was sober and incredibly brave, and I think all credit to her. Think of the enormous pressure she's under here and how brave this decision is to respect the rule of law and to respect our Constitution.
Well, good job to you guys and to the outside lawyers at Landmark Legal Foundation. Good job to Attorneys General Misa Mulcahy. That's how serious this matter was. Two former Attorney General intervened in this case, and to their lawyers, their wonderful professors, and Donald Trump's lawyers. And I think lawfare is sucking its last breath, don't you?
I agree. I think it's dying a good death. Let's put it that way.
All right, brother. That's Landmark Legal Foundation. What's your website if people want to check it out?
Yep, landmarklegal.org. Landmarklegal.org. Thanks, Mark.
Let's put that up there, Mr. Producer, on all the social sites, and you can read all about them. I'm so proud of you guys. You have no idea. Thanks, Mike. God bless. Take care.
God bless.